Individuals can be held liable for the act of trespassing on another's land. But is a trespasser liable for any damages caused by his conduct, or only for damages that are foreseeable? The Ohio Supreme Court considered the limits of trespasser liability in Baker v. Shymkiv. On the evening of March 22, 1978, Homer and Mary Baker returned home to find a car blocking their driveway. The car belonged to the Bakers' next-door neighbors, John and Molly Shymkiv, who were loading tools into their trunk. When the Bakers exited their vehicle, they discovered the Shymkivs had dug a trench across the Bakers' driveway. The trench allowed the Shymkivs to drain water from their own property across the Bakers' driveway and onto the property of the Bakers' adjacent neighbors. After Homer walked over to John and started yelling, Mary attempted to intervene. The men continued to argue, and Mary went into her house to call the police. 3 minutes later, Mary returned to find Homer face down in a mud puddle as the Shymkivs drove off. Homer was rushed to a local hospital and pronounced dead. As the administrator of Homer's estate, Mary brought a wrongful death action against the Shymkivs, as well as an action for trespass. At trial, one medical expert testified that the events of the evening of March 22 could have caused Homer's death. A second medical expert testified there was no evidence to support that conclusion. The trial judge instructed the jury that before finding the Shymkivs liable, it must find that a reasonable person would have foreseen or reasonably anticipated the damages to result from trespassing and creating the trench. The jury ruled in favor of the Shymkivs on the wrongful death claim and ruled in favor of Mary on the trespass claim. However, the jury awarded only $300 in compensatory damages and $1,100 in punitive damages. The Court of Appeals reversed and remanded the case for a new trial, holding that the trial court's jury instruction was improper. The Ohio Supreme Court granted cert.